I want you guys to open up your packets, and you're going to see FFH local, and you're going to see FFH legal. I want you to take out those two papers. And then the other thing that I want you to take out is your Title IX procedures, okay? So these documents are the meat and potatoes. These are the requirements of what you have to do. If you get called on to be a part of a Title IX investigation, you're called on to investigate, you're called on to be a decision maker, you're called on to be a part of it. This is what you need to pull out. So when you go back to your materials, of course, you know, you've got the PowerPoint, but you're going to want to refer to these policies because that's the meat and potatoes, and these are where the requirements live. Okay, so let's go. All right, talked about the policies. So FFH legal, there's some definitions there. We talked about the definition of what sexual harassment is. That's on page 5 of FFH legal. Supportive measures, that's defined on page 6. You can put a star there. The formal complaint is also defined, and then what is actual knowledge. So right there on pages 5 and 6, you're going to see those definitions in FFH legal. Then that FFH legal also talks about, or there's some provisions that deal with, well, what is a coordinator supposed to do? Okay, the coordinator's duties are also listed in FFH legal. Emergency removal. You have a student who's engaged in sexual harassment under Title IX, and they are a danger. There's some provisions about how do you deal with that. How can you remove the student from campus? That's addressed there. And then there are requirements in FFH legal that require the district to adopt policies. Okay, you've got FFH local, that's one of your policies, and procedures, and these are the procedures. Okay, now I'll tell you, these are TASB's model procedures. Okay, every district, you know, adopts their own. I will be following up with your Title IX coordinators about Edgewood's procedures. But what I included in your packet is the TASB model procedures. Most school districts adopt these. Okay, so this is where the process is. So you will want to, if you get called upon to be a part of a Title IX investigation, these are the documents that you're going to want to refer to, especially the procedures, okay? So, and if different procedures are adopted, I'm sure that your Title IX coordinators will get that to you. But for the purposes of this presentation, we're going to be looking at the TASB procedures. Okay, so we've got the complaint process. There's some notice requirements. We're going to talk about some of those, and then what you have to do with the investigation. Okay, FFH local, if you read that, it talks about there's Title IX harassment, and then there's other sexual harassment. That's other sexual misconduct. It doesn't rise to the level of Title IX sexual harassment, but it is a type of sexual misconduct. Maybe it's, you know, kids, a couple of kids slap each other on their butt. They think it's funny, but we don't want that to happen, and so you don't deal with it under Title IX, and you're going to look at it maybe under other kinds of harassment. We're also, there are reporting procedures, and what that FFH local says is any student who believes that he or she has experienced prohibited conduct, and any person who believes that a student has experienced prohibited conduct should immediately, that doesn't mean like, well, it's spring break, Lisa, it's 2 o'clock, I only got a couple more hours to go before I get on my cruise. Do I really? Yes. Immediate means immediate. That means you stop. Doesn't say prompt, it says immediate. Immediately report the alleged acts to, who are you going to report it to? The student, they're going to report it to a teacher, okay? A school counselor, a principal, or other district employee, or the appropriate district official listed in the policy, which is going to be your Title IX coordinator. that or other district employee, do your bus drivers know what to do if a student comes to the bus driver and says, hey, this kid is touching me every time I sit next to him on the bus? He, puts his hand there so that, his hand can touch my bottom, or while we're on the bus, he'll grab at me. Do your bus drivers know what to do? These are important questions because we see this happening where somebody reports something and the person who it got reported to, they didn't know what to do. So they also, when you're having your meetings with your personnel, they need to understand this stuff a little bit. They may not know all the nitty-gritty like you do, but they need to know enough to say, hey, if this is going on, you get a report like this, you are directed to report it to this person, okay? Upon receipt or notice of a report, the district official shall determine whether the allegations, if proved, remember I always say, if they're true, would constitute prohibited conduct as defined by the policy. If so, the district shall immediately undertake an investigation, except as provided below at criminal investigation. Lisa, I told you I'm going on my cruise. You're telling me I have to stop and take care of all this? Yeah, you got to take care of it. You got to deal with it. Somebody's got to deal with it at the district. So if everything that they're saying is true, you need to immediately do something about that and follow your Title IX procedures. So that's what we're going to be talking about. Now, this is what the criminal investigation says. It says, if the law enforcement agency or regulatory agency notifies a school district that there's a criminal or regulatory investigation ongoing, the district, quote, shall confer with the agency to determine whether the investigation will impede, whether the school district's investigation is going to impede the criminal or regulatory investigation. This is important because I see a lot of school districts, this is another area where things run afoul. The one I told you where the student got raped, after school on campus, that was her allegation. The school district, unfortunately, the student didn't immediately report it. She didn't report it. It happened in the fall. She didn't report it until like 2 or 3 months later. She was kind of traumatized by the whole event. Well, I take that back. No. I'm thinking of another one. Sorry. This one that I want to talk to you about, she reported it actually the very next day. She reported the next day. School district did the right thing. They called the police. The police came out and they did an investigation. And so the school district said, well, the police did their investigation. They investigated it under their regular student code of conduct, sent the kid to, death. And the criminal investigation, because the kid, the alleged, perpetrator said, no, she said yes. And she said, no, I didn't. I said, no, I didn't say anything. I didn't consent. Anyway, you know what the police did? The police said, well, it's a he said, she said, so they closed their investigation, and the district relied on that. They didn't. They said, well, they didn't find anything. And so what the school district did is they sent the kid to DEP. You know what they sent him to DEP for? Lewd conduct. What is that? What's lewd conduct? Does that mean he exposed himself? And if it really was consensual, why are you disciplining him and not her? So it was kind of strange, but I understand why the district did it. And what happened is because the police told them, well, we can't really decide, who's telling the truth here. So they talked to the DA. The DA said that we're not going to take this case. And they didn't. And the school district, they wanted to do something because the girl wound up going and getting a SANE exam. Does anyone know what a SANE exam is? A sexual assault, examination. Very intrusive examination. Went to the hospital, had all that done. And the district wanted to do something, and so they got the kid for lewd conduct, thinking, well, we did something, but they didn't follow the right procedures. And eventually, the student and her guardian, they hired a lawyer, and they contacted the school district, and it got really messy for a while. So be careful about those criminal investigations. It doesn't say that you can hold off. It says you shall confer. And what that means is that you as a principal may not have to, if your Title IX coordinators are going to say, you know what, let me check in because we reported this to the police, we reported it to, you have a police department, right? Edgewood has an Edgewood PSD. Okay, so you report to your police officers, they do their criminal investigation, and say, you know what, we also have a duty to investigate under Title IX. If we do our investigation, is it going to impede your investigation? No. Then you just proceed. If they say, you know what, give us a week, let us collect some more information, and then you can begin your investigation. Then you can start. It just says confirm. It doesn't say that you have to hold off, okay? So just recognize that that could be an issue for you. This is who your Title IX coordinator is. So all of you on you got it right, Dr. Madkins. So if you put that on your sheet, you got it right. Now you know the answer to that pop quiz question. So this is in your, oh, you got it. Yeah, you did. Okay, well, all right. So here, you can take something from the bag. Okay, so let's go look. Let's look at your DIA local. Actually, your DIA local, those are your employee policies. There's also references to the procedures in Title IX, and all of those procedures are going to be listed in FFH. And so it says that if an employee feels like she's experienced or he's experienced prohibited conduct, the employee may report the alleged acts to his or her supervisor or the campus principal. So know that an employee could be reporting that they have felt like they've been sexually harassed as well under Title IX, and so they can report that to their supervisor or to the campus procedures, or they can also report it to to the designated person. And here's who it is under DIA. Did anybody put that? Did anybody get that one right? You did. Okay, well come up and you can get something out of the bag here if you want. Feel free to take a prize. Okay, so that's those are who you should have listed, and I know you know who these people are. So that's who you would get these things reported to. So this is what's on your website. This is what it says as far as like who's listed there. You always want to be sure that you're checking that stuff out. You guys are busy, but if you look at something on the website or somebody tells you on the website it says something else, and take steps to correct it if there's any misinformation on there, because we want to make sure that things are accurate, because if OCR ever does an investigation, those are one of the things they're going to look at is your website and make sure that all that's accurate. Okay, so the formal complaint procedures. In those TASB model procedures, okay, that's this document right here. You can put a big star and say, TASB, model formal Title IX complaint procedures. That's what's in there. It talks about all of these topics. Supportive measures, how quickly do we have to resolve complaints. So the one I gave you was kind of a trick question. So we have 60 business days to resolve a complaint, but to investigate we've got 30 days, and I've got that listed there for you. In the investigation, it's 30 district business days. So what does that mean? Well, weekends don't count. Weekends won't count, and neither does your winter break, neither does spring break. So it's just those days when the district is open, okay? All right, it talks about the notice requirements, so we're going to talk about some of that. The investigation report, a very important document. We're going to talk about what needs to be in your investigation reports. How do you determine who's responsible? The remedies for appeal, appeal procedures, and then remedies, like how do you fix it if we find that one student is responsible, and then what about informal resolution? Is there a way to mediate things? Yes, there is. We'll talk about that, and then records retention. So I want to make sure that Sonia gets, her time. So I'm going to be going, we can just spend all day with this. So let's talk about this. So upon receipt of a report alleging sexual harassment, the Title IX coordinator will promptly contact the complainant to offer supportive measures and interact with the complainant too. And I gave you a sample letter there that addresses these things. The reason why it's important that you all ask questions, because if it does trigger Title IX, the only way that the Title IX coordinator is going to be able to comply with her duties is if you've reported it to them, because she's not in the classroom, she's not at the campus. So you need to make sure that you're reporting it if you think it might trigger that, and let her help you decide whether, if you need help, that no, this doesn't trigger Title IX, look at it under your regular student code of conduct, okay? So Make sure that if you think it's Title IX, you've got to report it, because then it triggers things that the Title IX coordinator has to do, and one of those things is to give information about supportive measures. Okay. All right, so that's what it looks like under the general response. Again, FFH local. So what are supportive measures? These are individualized services. So you can't just say, well, this is what we always do. Everybody gets, a campus escrow. We just do increased monitoring. No, they're individualized. You've got to look at what is going on, what does the student need to be successful in the classroom. And if you look in your packet, I hope that it's in there. One of the things that's in there is it is a supportive measures form. And yeah, so this form, this is a supportive measures form, okay? That's listed there. This is just a sample form. Doesn't, you can use this, you don't have to, but just some measures that perhaps that were discussed. I mean, typically that's going to be with your Title IX coordinator, but you'll see that accepted, not accepted. That's important because your procedures say that you need to note whether the supportive measures that you offered were actually accepted or declined by the complainant. Just remember, when we say complainant, it could be the complainant's parent. So it could be that you're interacting with mom and the student, okay? But you do have a letter in there. And the other thing that's very important with these procedures, so my two Title IX coordinators, the procedures say that the Title IX coordinator is responsible for coordinating the effective implementation of supportive measures. What does that mean? Well, Lisa, I told them that, that this is a person that they're supposed to contact, and that the student is supposed to be getting an escort on the way to every class, so she doesn't, so she's not afraid. But then it never got communicated to the people who are in charge of putting all that together. So really, you campus principals, if there's going to be supportive measures, you need to be working with your Title IX coordinator to make sure that they're helping you implement those measures, okay? You guys need to be talking to each other. I see it time and time again. Well, we offered supportive measures, and this is what we put down, but nobody is making sure that those measures are being implemented, okay? So you got to do that. What are some supportive measures? You guys, I'm sure know these things. It can be counseling, extending deadlines, mutual restrictions on contact between the parties, increased monitoring, changing seating assignments. Okay, those are supportive measures. The Title IX coordinator, if there's a formal complaint, somebody actually, a sample formal complaint is also in your packet. If that gets signed by a parent, and maybe it gets given to you rather than the Title IX coordinator, the coordinator is going to evaluate the complaint to determine whether, if everything they say in that complaint, if it's true, does it trigger the process, and then they're going to follow the applicable procedures, okay? So that's what happens following a Title IX formal complaint. Now, when I talk about formal complaint, I'm talking about that document in your materials that looks like a complaint form. So I'm not finding it, quickly here, but there's should be a form in there for you. I don't know. I'll find it. But there's a formal complaint form. So once that's signed, that's going to trigger what the district has to do. Okay. Again, that's what it looks like in the procedures. Okay, the burden of gathering evidence and burden of proof. Who has a burden of proof in a Title IX investigation? Is it the person who made the complaint? No. No, you know who has a burden? The district. It's the district's burden. It's the district's burden to prove whether or not it happened. And I know, like, we're thinking of it in terms of criminal, and that, well, it's whoever's bringing the complaint, they have that burden. No, it's the district's burden. And so that's why if you get tasked to be an investigator, you need to take that job very seriously, because you've got to collect the facts so that whoever is the decision maker can make a decision. So you've got to be thorough. You've got to collect all the evidence. So the burden of proof and burden of gathering evidence sufficient to reach a determination regarding responsibility, who's at fault here, or, whether the respondent is at fault, rests with the district. That is in your Title IX procedures. And that's how it is. I was going to see if I wrote, the page number. Actually, it's on page 8 of your procedures, okay? All allegations are going to be investigated. That means what? If they have a bullying allegation embedded in that formal complaint, even though it's bullying, guess what, you investigator? You're going to have to investigate that bullying allegation as well. Don't think, well, I'm only doing the sexual harassment. I'm not. Somebody else has to do this. No. You have to, every allegation that's in there, break it down. He said that, it's been teased, ridiculed, whatever, since all this has been happening, whatever it is, you have to investigate it. Every single allegation in that complaint has to be investigated. Absent good cause, the investigator has to complete it within 30 days. That's not a lot of time. I know we're not counting, holidays and stuff like that, but you guys are busy. So 30 days, if you know that you've got something coming up that's going to keep you from completing your investigation within 30 days, you need to contact the Title IX coordinator and say, hey, FYI, I've got surgery scheduled. I cannot get this thing done in 30 days. You need to tell them immediately so that they can assign somebody else, because the district is going to be expected to comply with these timelines. And we may think 30 days is a lot of time, but it's not. It's really not, and especially given everything else that you guys have to do. So, TASB and those model procedures, when we say days, we mean district business days, but still not a lot of time. Preponderance of the evidence, that's something else that is required to receive information about. What does that mean? Well, think about the OJ case. What happened in the OJ case? Was he found guilty in the criminal court? No, he got off scot-free, right? The glove didn't fit. They acquitted. So then what happened? The family sued him in the civil court. Was he found liable in the civil court for damages? Yes. Why? Different standard of evidence. Same kind of facts, right? Different standard of evidence. The same is true here. The example I gave you before with the police, what happened there? Right? The police said, no, not enough. That doesn't mean that it's not enough under your procedures, right? Because it's preponderance of the evidence, more likely than not. And I don't know if you can see on my picture there, but there's a feather. That's all it takes. It's like, is it 50 and a bit? Then that's a preponderance of the evidence. So 50-50 is equal, 50 and a feather, that's preponderance of the evidence, okay? That's what you need to meet that burden of proof. This is the informal resolution process. It does live there, interesting enough, and I've never seen anyone take advantage of this process. It has to be voluntary. Whenever you're giving out notification about, the Title IX process, this is one of the things that you have to tell them about, and I included that in the letters, that it's voluntary. You have to get written consent of both parties, and you cannot use this process if the allegations against an employee. So it will not apply to an employee. It can only apply like allegations between students, okay? Anybody who facilitates the informal resolution process under Title IX, guess what? Has to be a trained person. And then while you're going through this process, those days won't count against you. So you go through the informal resolution process and one party says, I stop, I don't want to do this anymore, that's fine. They withdraw and then you just resume the investigation. But those days that you spent going through the resolution process will count against the district. Using privileged and confidential information, this is another area that I see that gets people tripped up. I see districts that don't want to, they send a notice to the parent, of the perpetrator, and it says that, your student sexually harassed AB. And that's it. It doesn't have any other facts. And it was a formal complaint that was signed, but they still refer to the student, or student 1 or student A. They don't reveal the identity. The law actually says if you get a formal complaint, and it's signed, by the complainant, then you have to reveal the identity of the other party. If the other party wants it to remain confidential, you can investigate, but it's not going to be the same thing. But the identity of the parties is going to be revealed, and that's very important because I know you guys are using FERPA, but when it comes to Title IX. And in fact, there's even like some FERPA opinions about this, that, if it's sexual harassment, the perpetrator has a right to know who is making the allegation. Because how can you defend yourself if you don't know making the claim against you. So in that letter, following a formal complaint, you have to identify the parties. But anyway, getting back to confidential information. One of the cases that I have, remember I told you when the student went to see, got a SANE exam, the lawyer wanted to bring in that SANE exam as evidence to show that this girl had been sexually assaulted because it showed that there was trauma, following that encounter with that student. And so they wanted to bring that medical report. And I told her, if you give me that and you want the investigator to consider that, they will, but they get to see it. They're gonna, everything that's collected, remember I told you, everything that's collected, including medical, information can be shared, but you have to consent. So if you want us to, you've got to give me written consent that I can use it for those purposes, for the purposes of this investigation. And I also told her if there's stuff in there that you don't want, them to see, you can redact it. Send it to me, you can redact it. And that's exactly what they did. They gave me the consent, or they gave the district the consent, that it could be used for the Title IX investigation. They redacted certain, pieces of things about medication and things like that. But, the report about like the sexual trauma, that all remained, that was the party, so, and we'll talk about how you share information and what are some best practices when it comes to that. Okay, disciplinary sanctions following following a determination of responsibility. Decision maker designated by a Title IX coordinator will make an independent determination. That means, it's got to be just you, whoever the decision maker is. Don't be like checking in with the Title IX court. What do you think? Checking in with the investigator. What did you think? What were your impressions? It's got to be independent, guys. Okay, it has to be yours. You're looking at the facts and you're making your own decision. And the decision maker isn't the Title IX coordinator or the investigator. Okay, so don't be checking in with them. I know it's a tendency to do that. If you need help, call us if you want us to help you kind of think through this. We've done that before and we'll help with that. Remember that any recommended disciplinary sanctions that are in that final determination or in that report of determination, they're not final or effective until after the period of appeal is over. Okay, so they still get that right to appeal. The decision maker, you got to do a written report. So just because you're not the investigator, you also have a hard job. You've also got to write that report. And then review your student code of conduct, your rubric for disciplinary consequences, anything that you recommend in your determination report. Make sure it's based on something. Don't just say, well, he did this or she did that. I'm going to give him 60 days death. Well, go back and look at your student code of conduct. How does this conduct fall under your student code of conduct? Do you have a rubric for this kind of conduct? And make sure it's consistent. You can't go overboard with this stuff. It's got to be something that's fair. It can't be arbitrary. Your appeal procedures. Oh, yes.
A quick question on the naming conventions. You have the roles. You have a Title I coordinator, you have an investigator, and you have a decision maker. What's the difference between the investigator and decision maker?
Okay. So the investigator is, and I apologize, I've a lot more information that we're going to try to get through. So the investigator is a person who is designated by the Title IX coordinator to gather all of the evidence, gather all of the facts. They're going to meet with witnesses, right? They're going to look at the Snapchats or, see if there were any texts. They're going to contact the witnesses, okay? They're the investigator, okay? And that is one person. And it's going to be someone in this room if you get one of those, because it has to be somebody who's trained. It's not going to be your Title IX coordinators. We know who those people are. It's not going to be them. It's going to be one of you. The investigator is going to prepare a written report. And the written report is going to have all of the evidence collected attached to it. When that written report is completed, and after it's been shared with both parties are going to be able to see it, that written report is going to get forwarded to who? A different person, a decision maker. And that decision maker is going to review everything in that report. And the other thing that decision maker is going to do is going to contact the parties, and he's going to tell the parties, you can send me some written questions that you want asked of the other party. The other party doesn't have to answer them, but if they're relevant, questions that pertain to the facts. Okay, you submit them to the decision maker, and then they can present them to the other party, but the other party doesn't have to answer it. Okay?
Does the investigator have to be from that particular campus or department, or can it be an outside?
It can be an outside, that's going to be up to your Title IX coordinator. And that's why I'm telling you guys, like, if you know that you're very, very busy, or you're going to have a surgery, or something's coming up in your life that's going to keep you from meeting these deadlines, please, 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 as soon as it gets assigned to you, say something. That I cannot, because of the other tasks that I have at hand, I can't complete this in 30 days. And then you, the decision maker, if you can't do it within a certain period of time, you also need to speak up. Because I'm telling you, these reports are not easy to write. We're going to try to develop some forms that are going to help you with that, but they take some time and they're tedious. So make sure that you're taking the time that you need to prepare your report. Okay. I know we're going kind of fast. So following that decision, again, the decision maker is going to have a report. And that report, if you look at your procedures, there's some things that have to be in that report, including an analysis. Like, you've got to make some findings of fact and then apply the facts to the allegations, or like apply the allegations or the facts, I'm sorry, to the definition of sexual harassment. You're going to have, if it was severe, pervasive, and offensive, you're going to say, well, this is, she said that it happened, 4 times, and these were the people that said it, and it happened here. All of that. Does it meet severe, pervasive, and objectively offensive? You're going to want to explain that in your report. It's got to be thorough. You can't just say, yes, I find that it's severe, pervasive, and objectively offensive, or no, I don't. You have to explain. Show your work. You teachers, we always say show your work. This is one of those areas where you got to show your work. Okay, they have 3 days to appeal. Appeals can only be based on 3 things, and that's a procedural irregularity, new evidence, or if the coordinator, investigator, or decision maker had a conflict of interest or bias. Okay, conducting investigations, we're going to get through this a little bit more. So we know we've talked about 30 days. Your report, and I gave you a sample notice in there. If you're the investigator, you need to give the party who's participating in that a written notice of the date, time, location, and the participants and purpose of any investigative interview or other meeting with sufficient time for the party to prepare. Give them at least 2 days. If you can give them 3, give them 3. Okay, whatever you give to one, make sure you give it to the other, all right? So 2 to 3 days, to prepare for that interview. But remember, you've got to give them written notice, okay? All right. All right, they can have an advisor of the party's choice. It can be an attorney. It doesn't have to be. They have a right to bring an attorney. They can bring a grandmother. They can bring a parent. There are times when you can delay that 30 days, especially if they say, I have an attorney and the attorney can't be present. Can you do it on X date? And so you have to extend the deadlines. That can be good cause. Document that in writing. Do a follow-up, even if it's an email. Copy your Title IX coordinator and say that we're extending the deadline, 3 days to accommodate, the respondent's attorney. And if you give the respondent 3 days, follow up. Does the complainant also need additional time? They may not. Sometimes people want to get these things over with quickly. Yes.
You still have to finish within 30 days?
I'm sorry?
But you still have to finish within 30 days?
Not if it's extended for good cause. Okay, so it's 30 days. Absent good cause. Okay, so you give them 3 extra days so the attorney can show up, then it's now 33 days. Does that make sense? Or maybe 36 days, because now you're going to give the other side 3 days. Okay, inspection of evidence. Remember, we talked about you're gathering all of that evidence. What the procedures and the regulations require is that once you have done all of your interviews, once you've collected all of the evidence, once you have everything, and you're ready to start writing your report, you have to make available the evidence submitted by the parties obtained that is directly related to the allegations raised in a formal complaint, to inspect and review. That's different than I get to take it and run away with it and have it, take it home with me, okay? So inspect and review. What we've done in the past is, there's a way to send things electronically, and you can limit them from sharing it, right? So you can, because a lot of times, like these, the evidence is going to be a lot. So there are ways, and we have a tech-savvy person, they can, explain this to you, but there's a way that you can share it electronically for a period of time, like 10 days, but when you share it with them, the only access that they get is to view it. They can't forward it. I guess they could take a screenshot of it, but that's all they can do. And that's how we handled it for one case, because the attorney was in a separate part of the state and couldn't see it. So, and then once we allowed the complainant to have it electronically, then we offered that to the respondent, and they said, yes, I also want it electronically. Okay, fine. The other thing you can do is you can make it available at your campus. They can come, they can look at it in a room, and inspect the evidence. They can't take it with them, but they're going to have to be monitored, right, to keep them from, taking parts of it or whatever. So just know that you're not going to give them everything as a copy for them to keep forever and ever and ever. You just have to allow them the opportunity to inspect it and review it. Okay. So you're going to send them all of the evidence. I also gave you in your packet something else that's, I guess, a sample notice. I don't know if I'm seeing it. It's a chart. I don't know why. Do you see anything like that? Evidence checklist. Is that what it says? No, it's it looks like, well, I'm not seeing it. It's a little, like, table that has evidence on it, and it's just, yes, that's it. Yes, that's it. I don't know why I'm not seeing it in here. So that, I would recommend you, if you're an investigator, here it is. If you're an investigator, I would list every piece of evidence that you get. I would list it on a chart. Somehow you've got to document it. This is everything that I consider relevant in my investigation. And you're not going to just give them this piece of paper. You're going to give them the actual document. But you're going to want to have a list of everything that you're sharing with them. And you're going to tell them, this is everything that I see as being relevant. And then you're going to list the things that aren't relevant. For example, one of the things that was collected in one of our cases was, it was some students, a trainer's log, okay? And somehow it wound up getting wrapped up in the AP's investigation, and it was part of it. We didn't think that that was relevant to any of the allegations, so was it something that wound up being collected? It was submitted by the assistant principal who had done an investigation not under Title IX, under something else. That was something that wound up in the investigator's file. So what they did was they put it here. We don't think it's relevant, but they labeled it, August 12th, trainer's log, and then, it was listed here, as well. But it wasn't, and then it was just shared that that wasn't going to be relevant. The respondent actually called and said, no, we think it is relevant, and here's why. They made their argument, and that's fine, and the investigator said, okay, fine, I'll consider it. But, so it wound up, like, initially when it was shared, being at the bottom of the list, and then they went ahead and it got moved up. The other thing that was never on here, that both parties wanted in there, was a police report. And you know what? The district did have a copy of the police report. I said, did y'all get a copy of that police report? Oh yeah, they said, we got that. Well, how come you didn't tell me you got that? Well, because they found nothing. Like, well, both of them want it. It's relevant, so put it in there. And so sure enough, it wound up, going on that list. So that's why it's important, and I think that's why the rules are there, is, you got to be sharing with them everything that you're going to rely on, right? And they both felt like, they wanted that police report in there. Okay. So that's that. Anybody have any questions about that? How to send it? Sure.
So are you able to put other students' names or people's names on that evidence?
I mean, what we've done is we put their initials. The students are gonna know, who they are. Or you can, I mean, you can do an initial, or you can have a chart that says, Susie Q is student 1. And that's a log that is kept separate, and then when, in all of your reports, you're just writing student 1 was a witness and reported X. You see what I mean? But the complainants, identities, all of that, and sometimes both parties, they give their own witness statements and they list all the names of the people, so they're gonna know who it is, but you can handle it that way, is keep it key like you do for other things. Your investigative report. That's everything that has to be in your investigative report. So it's quite a bit things that have to be in there. You can see all of that. Okay, all of that has to be in your investigative report. Okay, any questions about the investigation? If you refer to your procedures, it's going to tell you everything that needs to be in there. Just always, I always tell people before you do anything, if you know that you're going to be assigned something and you're given the heads up, pull out your maroon packet, start reading those procedures. Start with that. You can always do that. Having a cup of coffee, read it. Highlight it, go back to it, go back to your notes about how do I do this, what's my role, and what's going to be required of me. Talk to your Title IX coordinators. They've got a lot of information and they can help you along the way, and they can also reach out to our office. Okay, determining responsibility. Okay, again, a separate person. So a decision maker designated by the Title IX coordinator is going to make an independent determination, and they're now, when the decision maker, let's say, one of you, you're designated to be the decision maker. You get that report, okay? The date that you get it from the Title IX or from the investigator, the Title IX coordinator, whatever it is, okay? Today, December, was it the 7th? Okay. Day 1 is going to be December 8th. You cannot issue your decision any earlier than 10 days, and again, when we're talking about days, we're talking about district business days, at least under TASB model procedures. You cannot finalize your report any earlier than 10 days. Why? Because when you get it, the complainant and respondent are also getting it, and they have the right to review it, and they get to submit written questions to you, and that they might want to have asked of the other person. Okay, again, a response is not mandatory. They don't have to give you a response. Okay, all right. So that's everything. That list there is everything that has to be in your determining responsibility. Your written report. Again, it's a written report. You have to give a report of the description of procedural steps, which is why it's very important that all of these letters and notices that are going out, whether it's from the investigator about the meetings, whether it's from the Title IX coordinator, all of that, you have to describe that. What does it say? A description of the procedural steps taken from the receipt of the formal complaint. On X date, the formal complaint was received. Then we did this. We send out these notices. So everything that was done. You got to have findings of fact. It's hard. You're going to have to make decisions about severe, pervasive, and objectively offensive. You're going to have to make a decision. I get it. It's going to be hard. It's going to be complicated. It's going to be sticky. Somebody's going to be unhappy. But you have to do that. And your conclusions, they need to be supported. Like whatever conclusions you make, they're yours. They're independent. Need to be based on whatever findings of fact that you made. And then you're going to give a statement and rationale for the result as to each allegation. Remember I told you have to investigate each one. Each allegation you got to investigate. So, well, Lisa, what about that bullying? Because I know we got a bullying procedure. Yeah, and we've had issues with that. So if there's bullying wrapped up in that or a separate bullying allegation, then what you can do is say that you find that there's evidence that supports that, but then the principal, the campus principal, can then, proceed with the punishment on that end, okay? But you just need to make a finding as to each allegation contained in that report. Also can't consider complainant's prior sexual behavior. Let's say that, part of the evidence that was submitted is, a whole bunch of text messages or steamy letters from one of the parties to another party saying, well, this person has sex with all these other people. So yeah, they had sex with me too, and it was consensual. Can't consider their past sexual behavior unless it's used to prove identity or consent. Okay. Oh wait, is this yours? Oh no, I'm sorry, I'm on the wrong page. Okay. Let's see. Grounds for appeal. Under what circumstances must the school grant an appeal? It's going to be procedural regularity. We didn't follow a procedure. We messed up. You know what? I didn't send the parties a copy of the evidence, ahead of time. I didn't give it to them. That's a procedural irregularity, okay? Newly discovered material evidence that wasn't available. One of the witnesses was holding on to, some emails that were going out, and didn't come forward until after there was a decision made, okay? That could be it, or bias or conflict of evidence. Okay. Any questions? I know I went through that quickly, but I wanted to give Sonia some time to talk to you all about bias and conflicts of interest. Any questions? No? Okay. With that, I'm going to let Sonia take it away. Sorry, Sonia. I hope I didn't take up too much of your time.
I think that a lot of what I'm going to talk about, Lisa already touched on, and we'd really like to go over some scenarios with you at the very end, so I'll speed through this. But I'm listening to this too, learning and taking notes, because since the new regs came out under DeVos, it changed the landscape and made a lot of changes. Some is the same, but a lot more responsibility has been put on you all to perform these Title IX investigations, and that's what Lisa has been going over with you. And, I've been taking notes as well, just like you all, and I think that it's something, Lisa, we all tease each other, and I do a lot of the special ed law in our office, and so they'll always introduce me as the special ed law guru, which I resist. But Lisa, in my opinion, is the Title IX guru. So if I ever have an issue with Title IX, I will go to Lisa and ask her, what do you think? What do we need to advise our client? And one of the first, just what has stood out to me is, again, I think that supportive measures is very important. So once it is taken on as a Title IX complaint, and then the parent, usually it's going to be the parent, the grandmother, the guardian, whoever it might be, says, yes, I want you to do a Title IX investigation, the next step should be supportive measures, okay, for both of the parties involved, so don't forget about that. And again, I think that all these, I think some of y'all have asked questions that kind of geared me to me also recalibrating how I think about Title IX, is that you have your Title IX coordinator, and you have the investigator, and you now have the decision maker. It didn't used to be like that. So as some of you all have pointed out, probably, somebody in this room is going to be assigned as an investigator or a decision maker at some point under these regulations or any new ones that come out in the future. And that's why it's so important and actually statutory that you receive this training. And again, something that I've tried to stress, and Lisa has too, that even if it doesn't rise to the level of a Title IX and the district's not going to pursue it as such because it doesn't meet those elements, or the parents say, you know what, I don't want to pursue a Title IX. Don't forget you're still obligated to pursue under other avenues, such as a violation of the Student Code of Conduct or bullying, or even looking at if they're involved in extracurricular activities, what are some consequences that the students might receive under the football team's constitution or cheer. We've had a lot, like Lisa said this year, allegations of some bad acts happening in the locker rooms and on the school buses to sporting events or UIL activities. So something else to look at as consequences that you can look into, even if it's not Title IX. I'm going to talk a little bit about the biases because this is something that's stressed in the policies. I'm not really sure why, at least as the guru and has the history, we know that, those of you who may or may not be particularly interested in sports, probably most of us can remember when there was allegations of sexual assault, sexual harassment in the Baylor football program. Then there were some horrible things that happened at Penn State. One of the coaches, Sandusky, was found criminally liable for raping young boys on their facility property. I think these things brought to the forefront a lot of things that were uncomfortable for people to deal with and stressed that there need to be procedures in place and things thought of in a non-bias-like manner. Do we think that star football players would put their careers on the line and rape a young woman at a party? Surely he's smart enough not to do that. Would a nationally renowned football program really allow one of their employees to sexually abuse and sexually assault young boys in their facilities? I can't believe that would happen. We all have these individual biases that we have. We're human. And, the regs want to make sure that when you get assigned a case as an investigator or a decision maker, that you not analyze the facts under that bias. So let's look at the next slide. And Lisa, you're going to have to help me with these because I was like, what does that mean? Let's see. Okay. So remember that if you are assigned as an investigator or decision maker or involved in any way in a Title IX, maybe just assisting, fact finding, to treat the complainant and the respondent equitably. And that means an objective evaluation of relevant evidence. So consider whether you have a conflict of interest or bias. Lisa talked about informing your Title IX coordinator. I don't think I have a surgery, or my son's getting married in 2 weeks. I don't think I can complete this investigation. You might have an issue where your daughter is best friends with the perpetrator, accused perpetrator, or victim, and you need to let the Title IX coordinator. I'm not the person to do this because I have a bias, I have a conflict of interest, or I'm best friends with the parent of somebody involved in this complaint. The presumption that the respondent is not responsible for the alleged sexual harassment determination regarding responsibility is made by the decision maker. Even before the new regs came out, and even now, we'll get a call from a client and we will hear from staff, maybe the principal, that couldn't have happened. That teacher is in that classroom, her eyes are on all kids at all times. There's no way that a child could be sodomized in the hallways because we have teachers at every door. They're both special ed students. They don't have the cognitive ability for this to have happened. They're in kindergarten, there's just no way this could happen. And this is what these regs are cautioning against. You have to leave that determination to the decision maker. Your job, whether you're asked to assist or be the investigator, is to gather the facts. You don't have to be the judge and jury. As I would tell, clients who call me, say, well, I'm not sure, she's made this allegation before, we know that, she's McKinney-Vento, and all these things that you're not being malicious, but as an educator, you might be, or just being human, you're thinking in your mind. She has limited verbal ability. I don't think she was saying what she meant to say. Throw that all out the door. Take everything as true. Report it to your Title IX coordinator. Let the procedure follow, and then leave those things to the decision maker. Don't make presumptions, and don't let your personal biases have an impact on that. Remember that, again, the DeVos, the ones that were approved under DeVos, make clear that both parties are entitled to supportive measures. So it's the complainant and the respondent. Both parties are entitled to reasonable notice, as Lisa already went over with you, and the procedures are entitled to provide evidence in support of their position, And the investigation has to be impartial, free from bias, free from conflict of interest. So a conflict of interest occurs when a personal or private interest potentially compromises someone's judgment. This could be actual, perceived, potential. So again, we went over an obvious conflict is if there is a blood relation or by marriage or any other way you feel I am too close to this investigation because, my kid, is in cheer with this kid. And that you are the parents or you're close to the parents. Different, situations that might come up that you need to recognize. So being neutral is very important. Avoid sex stereotyping. I'm hoping we are moving away from this, but we all know as professionals in this room that we hear of females and males being perpetrators. Lisa gave the example of a young woman texting a male, if you don't have sex with me, I'm going to rape you. And, he's 300 pounds and she's 100 pounds. And there was a little laughter in the room, and I get it. We have to keep some levity in these situations, but those are the type of biases that we don't want creeping in, where it's like, there's no way that's going to happen. Kids will be kids. They were just teasing each other. That's what kids do. They're curious. They're exploring their sexuality. You all are the educators. We're attorneys. So I will talk. I've talked to principals, administrators, and heard those very things. They're teenagers. Their hormones are out of whack, or they're second graders. They're curious. The little boy said, "Show me yours. I'll show you mine." These kids are curious. I talked to the parents. Everything's good. Those are the kinds of biases. Even though you are educators, and professional educators, and you know your profession, the regs are trying to get you away from that thinking. And like Lisa said, probe, ask the questions. Okay, well, when could this have happened? The teacher says she has eyes. She's my best teacher on campus. There's no way this could have happened. I'm going to take down the parents' complaint, but I consider it closed. I don't have to report it. Talk to the parents. We're all good. Kids are great. They're both on honor roll. No problems. Supportive parents. There's no way this could have happened. Throw that thinking out the window. Take the call, probe, ask the questions, and think, do I need to report this to the Title IX coordinator? Okay, so we have examples of types of biases, and I was telling Lisa, maybe some of you have a psychological background. I don't, or have a major in psychology, so I was Googling these earlier about what all these are, and you might think that they're a little esoteric, but I'm thinking about all our real world scenarios that have happened in our practice. Like, yeah, I've run across this. A cognitive bias, which is info processing through a filter of personal experience. So again, we're human, and we might think the locker room incidents that we've been hearing about, boys and girls, slapping each other on the butts, flipping towels against genitalia, taking pictures in the bathroom stalls of each other. Again, boys and girls doing this year. And I was never an athlete, but my husband was. And I said, is this something that y'all did in high school when you were part of the football team? Is this just boys being boys? Is this just what occurs during slumber parties, And you think, and you can use your personal experience and maybe look at something and think, yeah, I was an athlete, it's just hazing. We did that to the freshmen when they made the football team. Well, that kind of thinking has to go out the window, but that's the type of bias they're talking about. Don't just think, that's normal behavior for our football team in our small town in Texas. Everybody has to go through it. I went through it when I was in high school 20 years ago, and now my son has to go through it. Those are the kinds of biases that we've run across, and that's what they're talking about. Boys will be boys, and all football players do that in the locker room. The tendency to perceive meaningful connections between unrelated things. So again, I give an example of the Me Too movement. I think we all know what that is, and we probably all have our personal feelings about what that is. So don't let yourself think, oh, this is just another female being sensitive or making another allegation. You have to throw those biases out the window when dealing with Title IX, and they really stress that. Another bias that I've run across, because I do handle special ed, and I've already mentioned it, is when it deals with special ed students. And we had one, that was our first Title IX investigation together, me and Lisa, and it was during the pandemic, and it was 2 special ed children, elementary school, and both of them have autism, so limited verbal ability. And this was before the new regs took effect, so we were still analyzing it under the old regs, under the old regulations. And some administrators may have said, there's, again, no way this could have happened. You know, we have 2 paraprofessionals in that unit, teachers, one of my best teachers, this couldn't have happened. And they don't have the cognitive ability. The little boy doesn't have the cognitive ability and, you know, doesn't realize what sexual gratification is yet. Okay, maybe. But again, you don't have to be the decision maker. You take the parent was saying this had happened to her child. The little girl did have very limited ability, and that's something I think that you have to realize too. If you get a complaint from a special ed student, consult your special ed department for help. How is it best to handle this? And the parent might say, yes, I want you to talk to my child, and there may be limited verbal ability, so I think that would be a situation where you do confer. Or maybe the parent will say, I don't want you to talk to my child. So you're going to document that, and like Lisa and me were talking about scenarios on the way up here, write a letter to the parent during your investigation, acknowledge, I offered to talk to your daughter, you declined, you know, so you document it and you proceed as is with your investigation. My point in all this is, despite these students or an accuser or a respondent, a complainant being special ed, despite them being on the honor roll, despite them having gone to DAP in the past, you can't let those biases affect your investigation. So always have an open mind, avoid prejudgments of facts, witnesses, or parties, keep out your personal beliefs. And, you know, we live in an age where there's a lot going on in our country, in our world, so we have to keep those out of our job in analyzing a Title IX investigation and complaint. If you don't think you can serve impartially or that you have a bias, actual or perceived, say something to the Title IX coordinator, okay? It might be, I mean, and again, we've tried to use real-world examples in here, and you may have a very personal reason why you don't want to be involved. Maybe you yourself were a victim of sexual assault, sexual harassment, or your children, or your mother, or somebody close to you. And that might be a reason where you have to really be honest and say, I don't think I can serve in this capacity. And when you are doing, and Lisa touched on it, and I let her chime in because she's had more experience recently under the new regs during Title IX. But what is relevant? And relevance, and we use the federal rules of evidence because this is a federal law. It means that if a fact were to have no bearing, that the rule defines relevance as having any tendency to make the existence of any fact that is of consequence to the determinations of the action more probable or less probable than it would be without the evidence. In other words, if a fact were to have no bearing on the truth or falsity of a conclusion, it would be legally irrelevant. So like Lisa was talking about, there probably, certainly, I think we've experienced it, where somebody is accused, and usually it's a young man, and the young man will say, well, this girl, you know, she gets around. You know, she's texting my friends, let's meet, you know, at midnight by the whatever so they can have sex. They're going to talk about, you know, that's what we experienced later. Or look at these texts, or look at how she's dressing, or look at her posts, and, you know, a lot of social media. Is it relevant? And I think, Lisa, is it relevant to your investigation? The regs already tell you it's not, right? A past sexual history is not relevant. But unless it goes to maybe a prior relationship that they may have had. But those are the things you really have to look for. Do you have anything to say on that, Lisa, on relevancy?
I think, happens is during the investigation, you're gonna ask them, is there anything that you want to share with me, about the allegations that are related to the allegations? And they'll, say yes, and they may give you a whole bunch of emails or texts or copies of snaps where, the boy, he was having sex, with all these other people, and so therefore he wanted to have sex with me too. Well, is that right? Does that really add up? I mean, does that make, okay, yes, he may have been having sex with all these other people, but does that mean that he had sex with you? No, right? It doesn't have anything to do with it. That's something completely separate. And like the issue that I gave you before, that trainer's log, we had listed that because it wound up being something that got wrapped up in the information, but there was nothing in that trainer's log. What the respondent was a student athlete. What did that add to the investigation about whether the student, sexually assaulted the complainant? The trainer's log said, he came here, on this date, and I wrapped his leg, and then he left and the time. And it was even on a different date. It didn't have anything to do. But nonetheless, the parent said that it was relevant. It was a piece of paper. It didn't matter one way or the other. It wasn't going to be added to it. And so they wanted, that to be, moved up in there. And I think ultimately the investigator did put it, in there. But I mean, once you do that, you say, well, how is it relevant? It's not. It didn't. Did it add to any information to make the allegation, which was on X date, this student had sexually assaulted this other student? The fact that there was a trainer's log from another thing, I mean, does it show that he wasn't capable of it? No, it didn't even say what body part. But so anyway, just be aware of that. You need to be asking. If someone wants to give you something, why do you think this is important? Why do you think I need to include this or refer to this in my report? Don't be afraid to ask that. Can you explain to me how this is relevant? It's okay to ask that question. And you might not know. Ask it. It's okay.
And here on this slide is the rape shield rule of evidence, which is what Title IX requires investigators and decision makers to follow, which is a presumption that a complainant's past sexual conduct or sexual history is not admissible unless it meets certain exceptions. One, the questions and evidence are offered to prove that someone other than the respondent committed the conduct alleged by the complainant, or the questions and evidence relate to specific incidents of the complainant's prior sexual behavior with respect to the respondent and are offered to prove consent. So again, maybe the respondent is saying, hey, we had a past sexual encounter and it was definitely consent, and here are my texts to show that it was consensual. Or, perhaps the victim or the complainant was, under the influence, and there's some evidence to show, that yes, a sexual assault happened, but maybe the respondent is saying, I wasn't even at that party, it's somebody else, and here are the texts showing that complainant actually had a sexual encounter with another person. So those are just examples. Just to push through, just because I think we do want to give some scenarios. Record keeping is very important, as Lisa said. I mean, we all know that every time you come here to speak, we're talking about document, 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 right? So the entire response and process related to the allegations, you need to at least keep a minimum of 7 years. And that's why Lisa's been talking about, and even what's not in here, go that extra mile and submit extra. Like I said, because we were talking about different scenarios on the way up here, I was like, well, what if the parent says that we had a situation recently where there was a teacher reported to, I don't remember who, hey, this middle school teacher, I saw them having lunch at the high school campus, and they were eating off each other's plates, and it just didn't look right. There wasn't any view of them kissing, any other evidence that there was any romantic or sexual relationship. But the teacher saw them eating off each other's plates and having lunch together. I mean, how many kids have lunch with their teachers? 2 females, female
intimacy, right?
Yeah.
I mean, who thinks that that's a little bit strange? See, and then she also said that I see them spending time together, walking alone together, where it's just the 2 of them. so it was that too. So,
But nothing that that teacher could put a direct link. Two females, female teacher, female student. So again, think about your biases that might creep in there. Think about, your bias of, well, it's a high schooler, she's about to graduate, she knows what's going on. It's not like you're talking about maybe a sixth grader who may not be as aware of what's happening. So it was reported. The district called the teacher in, and the teacher said, no, I'm just her UIL coach. I'm friends with the mom. Is there another bias creeping in there? Teacher, well-respected teacher, had gotten her UIL kids to state. So they're thinking, this is an awesome teacher. We haven't been to state in 10 years. Is there a bias creeping in there? Teacher says, I'm friends with the mom. We're good friends. I've known her, since high school. Kid babysits my kid, teacher says. Bias, bias, bias. Is the person listening is thinking, oh yeah, there's nothing there. There's probably nothing there. Okay, so they call the teacher in. This is what she says. Oh no, I'm just the coach. She babysits my kids. I'm friends with her mom. And so they document that they have talked to her and say, just be careful. They don't give any directive. You are not to eat lunch with the student. You are not to be alone with that student without another personnel being present. She drove her to different UIL competitions. Alone. They never said you are not to do that anymore. They just said kind of be careful, be aware, doesn't look good. Okay. So now, a year later.
What happens, the student graduates and goes off to college, and the student makes an outcry because they were having a sexual relationship. And now the teacher says, if you break up with me, I'm going to kill myself. The teacher was depressed. And so the student then made an outcry to her sibling, and the sibling told the parent, and the parent told the school.
So my original reason for bringing that up was that they did contact the parent, of course, which was great. They contacted the parent verified all that. Oh yeah, my kid is just, close with this teacher. They are in this UIL matter together. She does babysit. I'm satisfied with what you did, district. Thank you for letting me know. But you don't need to talk to my child. We're good. I'm good. I'm glad you investigated. I'm satisfied. Okay. So I had asked Lisa, what do you do in that situation where mom says, I don't want you to talk to my kid. She's already freaked out. The kids are already talking about her, or whatever. I had teenagers fairly recently. Don't call mom. Don't call my teacher. No, don't make a big deal out of it. Okay, so I get that the kid may have said that. So I told Lisa, yeah, that could happen, but you document, parent, I, requested to speak with your child about such and such allegation. However, you declined for me to do so. Please, call me if you change your mind, blah, blah, blah. Document. That was the point of this story, but also to show those other biases that kind of creeped in this investigation. You don't want to believe it's true. None of us want to believe that something like that could happen. And I think sometimes we let ourselves think, okay, yeah, oh yeah, you're her UIL coach. Okay, now I get it. Oh yeah, you're friends with the mom. So yeah, I get why they're close. You can't let those biases creep in. What were you going to ask, ma'am?
How about receiving a letter from the parents stating that they have permission, they're giving their permission for this employee to transport?
Yeah, I think ideally that's what they should have done, right? Have that documentation to show that it's okay for a teacher to transport to UIL competition or whatever it was, and your social media. You should be having your coaches and teachers acknowledge that social media where you're not supposed to converse with or send texts or converse only about district business after a certain hour without the parents' consent, things like that. So and that's the point, is everything seemed to be copacetic. Mom was okay with it. She knew that this teacher was, spending time with this kid, that they were going together to UIL, that the district had performed some sort of investigation. It was never reported to the Title IX coordinator for the district. What we see a lot is principal says, again, how many times have I heard this? I talked to the parents. They're fine. We're good. And I'll say, no, you need to report it to the Title IX coordinator. So we never found out about it, but a year later this happened.
Yeah.
And so all this information came out. And so I told Lisa, I've had that encounter. And they did okay. I wish they would have, though, as somebody brought up earlier, given that lady a written directive to say, you are not to drive the student to UIL, you're not to be alone with the student, you're not to have lunch with the student. Because many times, it's not unusual, and I've encountered those, where the teacher says, nothing's happening. And they will call the kid in, nothing's happening, we're not having a romantic relationship, we're not having a sexual relationship, and we're never able to prove it. But that teacher goes and gets that kid out of class so they can eat lunch together, and that teacher's grooming that kid. Boom, we've got you, you're insubordinate, you're on paid leave, we're going to look to terminate or non-renew you. Because many times we can't prove it up.
Right.
But this happened to
Yeah.
come to light that there was in fact a
So
sexual
what would you do?
relationship.
I mean, you could give the directive, that was one thing that they didn't do, but what are some other things? You can't talk to my students. What would you have done? What are some other things that you could do to kind of flesh this issue out a little bit more? What are some other things that you might have done?
Contacted HR just to get guidance too, because there was an HR issue. She wasn't a teacher on my campus, so therefore what was she doing?
Okay, so you might contact HR, get some guidance, that's good, yes, and say, what are some, ways of dealing with this employee? How about the person who made the report? I saw them eating lunch together, I saw them walking alone together, I know they drove to UIL. How about going back to that person? Say, have you seen anything else? Was there anything else? Like they made a written report, but is there anything in here that you didn't put or that you've seen since you made this report that I need to know about?
What about, and I'm throwing this out there, what about talking to the known friends of that young woman? Do you think that would have been okay? Even though mom said, I don't want you talking to Sonia, student, because that might freak her out. What if you talk to her? Because that's often how also we get information. And sometimes, young persons share with each other, right? That
Yeah.
might have been an option too.
Yeah.
To
Exactly, talking to the friends. What about maybe, for that extracurricular activities, sometimes counselors go in and they do trainings, right? Could you go in and do a training about, what's appropriate conduct on trips, and if this is going on, this is how you report it, and if you're ever, what about doing something like that? Yeah, there are other things that you can do, and again, you would document all that because mom gave you the directive. And see, talk to the students' teachers. How's she doing in school? Is she staying on track? Are her grades the same? Does she seem to be engaged? Has there been any change in her behavior? There are other things that you can do, even if mom says, do not talk to my daughter. And so that's why, again, you have to be engaged and you've got to kind of go the extra mile and say.
And just, you can still do everything that you can and still not come to a conclusion that there was a sexual or romantic relationship, and that's kind of what happened here. The district did do something. I don't think if they were sued that they were deliberately indifferent, but my point also is good record keeping. This came to light a year and a half later, and the district had kept their documentation of how they had contacted the parent, how they had brought the teacher in, and had a written report, so to speak. They did, and that's how we knew they did not report it to the Title IX coordinator. But at least we know we have that documentation to show, what happened here. Now that all hell's breaking loose, and the had to call the teacher in, put her on leave, and she ultimately resigned, and making the reports to SBEC, and we had to do all those things. But there was somebody else who had a question.
Just before you just clarify a little bit, or on the parent requesting not to speak to their child, I just had the idea around that local forensics where it's happening in my building, we kind of act as parents to make sure that we're finding out what's happening and getting some type of understanding. And I know it's when something's happening in the building, or it's happening outside, but it's brought into the building and now it's impacting the school experience. And just trying to
I mean,
clarify.
if you say, this is impacting the school experience, I believe it to be, disruptive. It's affecting not just, this student, but other students, because some students now feel like, the teacher's playing favorites with this teacher. Then, you can go against the parent's directive because it is affecting the school environment. In this case, there was no indication, and because the girl, I think was a babysitter, I don't even know. There wasn't, a clear directive, like, no, don't contact her. It's like, you don't need to contact her, this is already a done deal. But we were talking about that scenario with, every now and then, mom will say, do not talk to them, I don't want you talking, because it's a sensitive subject, et cetera, et cetera, et cetera.
I think what happened in this scenario is more than just, it was kind of like a, we're good, you kind of settled it, there's no need to talk to her. You know, it wasn't, that's how I believe
Yeah.
it went down, though there was not documentation enough to show. But I agree with you that, you know, it depends on the situation, but I would agree with you that calling in the student, especially if it's immediate, and you're like, I need to, like, get this teacher off my campus, I have a serious allegation, yeah, I'm gonna call Sonia's student in and say, what's happening? You know, what, you know, are you texting with, you know, your teacher, your UIL teacher? Do y'all meet? Yeah, I wouldn't blame you for doing it. I'd say, yeah, you do what you have to do to protect the health and safety of your students. Absolutely, 100%. In this case, and that's why I was showing the bias kind of crept in, because I think they just thought, well, yeah, they have, you know, a personal relationship with a family. And again, we're not blaming the district. I get why they reacted. It's just a lesson learned for all of us. You know, how biases creep in, save the documentation, report it to the Title IX coordinator, document. We're hearing that was the conversation with the parent, but there's no documentation that that was the conversation with the parent.
And it's possible that the students would have come in and said that there's nothing going on. You know, I babysit for her. You know, I mean, that could have been happening, you know, as well. And so if you've got another teacher who sees something and they write enough things down and they put it in writing and they give it to you, that, I mean, to me, that always says a lot. And then to me, when I see, you know, you hear about one student eating off of a teacher's plate, and if they're not, you know, related to each other, to me, that always shows a level of intimacy between two people that they're comfortable enough. My husband doesn't even like for me to eat off his plate. You know, I've never asked him, like, is it okay if I have that?
And he was married for 25 years.
Yeah, so,
but I think that also, oh shoot, what was I going to say? I forgot. But good record keeping and, because I would say the majority of cases that come across our desk, the student has reported something to a teacher, or a teacher has seen something. So that's why it's so important for you all to give this training to your teachers. In my experience with my cases, that they don't come to the principal. The parent is not going to look on, most parents are not going to look in your student handbook, in your online policies and say, oh, Ms. Trevino's the Title IX coordinator, Dr. Matkin's the Title IX coordinator, I'm going to call. Most times the parent or the kid is going to talk to the coach or teacher. And that teacher, coach, counselor is going to have to know, I need to talk to my principal, and you all need to know, okay, this is what we need to do now, or I need to consult with HR, I need to consult with Cynthia Trevino or Dr. Matkins, and maybe we need to get legal involved, because we see that where sometimes it just stops. You know, a kid recently, I had a case where the kid told the coach, who she felt close to, I need you to make a counseling referral to me because I think my elementary school teacher touched me. That's what she told the coach. And the coach, to her credit, immediately did the counseling referral. She told the counselor, my elementary school teacher touched me, and boom, you know, we followed the procedure. But again, that's how it should go. It shouldn't just stop, well, I reported it to, you know, the counselor, the principal. We had one too where the principal just said, oh, I thought the counselor was going to handle it. And it stopped there. You have to go that extra mile and check up on it. Again, I'm not in the trenches like you all. I'm not an educator, but if it's happening on my campus and I haven't heard from the Title IX coordinator, I'm calling that Title IX coordinator, say, hey, I haven't heard back from you. What are we going to do here? You know, I want this teacher on leave. You know, we need to have some direction of what we need to do.
yeah, and coordinate with HR.
And coordinate with HR as needed. Here's a sample of record keeping. I don't know if you want
This
to.
is just a sample chart, like, and really this is more for the Title IX coordinator, but that is so that they can keep up with what's happening around the district, you know, because they're going to be, got to keep the stuff for 7 years, so we need to know who's got what and where all of the paperwork is living. But, you know, you need to kind of have some type of spreadsheet documenting, you know, how you're going to keep up with it, so that, you know what's coming in. I know we're getting short on time.
We have
got
4
about
minutes.
4 minutes, right? You got We've got some things, but I do want to go back to our little, like, our pre-test. Let's do the post-test. What are the names of your Title IX boards? Everybody know that? Does everybody know?
Yeah, Dr. Mackins.
Okay, and who, did anybody, I know we had at least one person. Is that something you learned today? Good. How long does the district have to complete its investigation? 30 days, right? Again, you learned that today? Yes, okay. If there's an ongoing criminal investigation, the district must wait for the police to complete their investigation before starting the Title IX investigation. That's false. Shall confer, right? So don't let them say, well, we can't do anything because we're waiting for the police. No, that's the wrong answer. Prior to completing a Title IX investigation, the investigator must send the evidence submitted by the parties or the evidence collected that is directly related to the allegations to each party. Is that true or false? That's true, right? Did you all know that? Oh, you knew that ahead of time? Oh, okay. Some people did, some people didn't. That was something new that, or you knew, but did anybody else know that? Yes. You did know? Okay, good. Some people, they think, no, I can't share this. A party may bring their adult family friend to serve as an advisor to them and attend all meetings and interviews. That's true, right? Did anybody not know that? Yeah, okay. So, and now the sixth and final thing, and I hope everybody answers the same. I know what to do if a student reports that he or she has been sexually harassed. Yes, okay. We've got some party gifts. I do have a couple of scenarios. I know we can do at least one or two. I want to make sure y'all know what to do.
Here.
Okay.
You got 3 minutes.
Okay. Mother complains to administration that her daughter, who is receiving special education services, told her that she was touched in the private area by another male student in the special ed unit. Both students are limited. We've done that one. Campus administration has doubts about the alleged verbal statements made by the female students because of her limited verbal ability. Mother insists that an assault occurred. What should the next step be? Yeah, so you contact the mom, you contact your Title IX coordinator, you go ahead and send that notice. You know what I mean? And so what if you send the notice and the notice says this is how you file a formal complaint? Because one thing that we didn't talk about, and I apologize for this, we've revamped our training, so that's why it may seem a little clunky, but what triggers you to do something and investigate, the appointment of the investigator, the appointment of the decision maker, the person who's going to hear the appeal, if any, is that formal complaint. That's what triggers it. So you are not going to conduct an investigation until you get that formal complaint. Now that doesn't mean that you don't do something, and that's why it's important that you think through what gets reported to you, because there are some notices that have to be sent by that Title IX coordinator, and she cannot send the right notices about what supportive measures that are available. And remember, you have to provide those even if they don't file a complaint. She can't know that until you report it. So in this case, I would report it to the Title IX coordinator exactly what the parent told you. And then, you know, your work is done for now, and then let that Title IX coordinator make all of those notifications and then see if mom files that complaint. Okay, and I think I've got 4 o'clock. Yes.
Just one thing I want to bring up about this population of students, just because they are not verbal does not mean that they don't have other means and methods of communication. And so we don't want to have that bias and think because they did not verbally say it, that they still did not communicate it, because they can.
Right, and that's such a great point. In this case, what happened, it was a principal that was a new principal of this particular school. He actually got reassigned, you know, because of something else, and he was not happy to be there. And so when the mom reported to the teacher took it seriously. She immediately, you know, turned around. What did she do? She reported to her principal. Her principal said to the AP and told the AP call, you know, some advocate service, because he didn't believe that it could happen. And so they just sort of put it off on this third party to follow up with the parent. So you're absolutely right. Again, a bias thinking, well, they can't, you know, they have limited verbal skills, then therefore they couldn't communicate that this actually happened.
And that's why I say, you know, communicate with your special ed department if you feel that that's necessary to make the student and the parent feel more comfortable, not just writing off, as this young lady was saying, that, well, don't assume just because there's not verbal communication, there's not more. Maybe the teacher has noticed the student was more agitated in the unit or the classroom. And what this parent had done was record her daughter on her phone and how she was complaining, and we couldn't understand the child, but the parent interpreted for her, and we took the parent's word for it. I mean, we didn't just shut it down. We had the investigator. This is mom's interpretation of the verbal communication. You could tell the child was stressed in the video. So it was taken into consideration. It wasn't just written off, well, she can't articulate words, so we're not going to consider it. So those are all things, again, like we were talking about bias. Yes, Joe?
One of the other things too, just remember that in this situation, it's a self-contained unit. So back at your campuses, you may want to double check, are your cameras, if your classroom is turned on, have you had that request, because this is where this came from the law, and why we have self-contained cameras in the classroom. So that has to happen every year, there's paperwork that's go up to that. Maybe one of those things that we just maybe double check, how the cameras work in those classrooms, if there is a request.
Yes, and remember that if there's an allegation, very good point, Joe, that it's just not the parent that can request it. It can be the administrator. You know, you get an allegation from a parent, and sometimes they don't know the exact date, especially if the child is cognitively or verbally impaired, but maybe they do. And that's what happened in our case. We know it was this week because of whatever reason. Contact your tech people immediately and say, hold that video, because I believe there's only a certain capacity that most districts have on those videos, so you can view it and make sure it's not erased. Okay?